Mr. Rosenthal, we'll hear from you.
Excuse me just a moment. Mr. Marshall? Is that yours? Mr. Chief Justice, and may it please the Court, the State humbly submits that enforcement of Texas Penal Code Statute 21.06 does not violate the 14th Amendment of the Constitution because this Court has never recognized a fundamental right to engage in extramarital sexual conduct, and because there is a rational basis for the statute sufficient to withstand equal protection scrutiny. I'd like to begin with a brief discussion of substantive due process. From a practitioner standpoint, it appears that the jurisprudence of this Court appears to resolve the means by which the Court entertains a claim of novel protected liberty interests. Since the Constitution does not expressly address the issue of privacy or of sexual conduct, we look to the Court's precedents and to the history of our people. If the historical traditional analysis applies, it then serves as objective guidepost to guide this Court, as long as those ideals and laws do not infringe on fundamental rights. The Court has maintained that designation of a liberty interest is not done with impunity, that only those interests that appear to be carefully identified asserted rights should be drawn and should be considered as liberty interests. The record in this case does not particularly show which rights the petitioners are asking to uphold.
I don't understand what you mean by that. Aren't we clear what right they're seeking to uphold?
No, sir. They're asking for the right of homosexuals to engage in homosexual conduct.
Right.
But there's nothing in the record to indicate that these people are homosexuals. They're not homosexuals by definition if they commit one act. It's our position that a heterosexual person can also violate this code if they commit an act of deviant sexual intercourse with another of the same sex.
Why aren't they seeking to vindicate the right of either homosexuals or heterosexuals to commit homosexual acts? What difference does that make?
Well, the difference it makes is as the record is set out, it does not really define the issues such that the Court can actually give the petitioners a specific form of relief.
But the statute, Texas has already decided that for us. It has called this homosexual conduct. So whether it's a heterosexual person or a homosexual person, the crime is engaging in homosexual conduct.
That's correct.
You don't even have to get to the, as I understand it, you don't even have to get to the characterization of homosexual. The statute clearly defines certain acts committed by or together with individuals of the same sex, and that's your class, isn't it?
Yes, it
What
is.
more do we need?
The class actually is people who violate the act, not classes of individuals based upon sexual orientation.
Well, I can see that your point may have some relevance on the equal protection side of the equation. Some relevance, I don't think it may be controlling. It doesn't seem to meet the arguments that's made under the substantive liberty part of the argument with reference to Bowers.
I beg your pardon?
It doesn't meet the petitioner's argument with respect to Bowers versus Hardwick, which they say should be overruled.
Well, of course, we believe that Bowers versus Hardwick is good law and substantial law, and that this Court should not overrule Bowers.
But that question is certainly clearly before us. I mean, this is your statute. You convicted the people for these acts, and you have to defend.
Yes, sir. And it's our position that Bowers versus Hardwick is still good law, that there's nothing that's changed about the fundamental liberties or the history or traditions of our country that should make the analysis in Bowers incorrect any longer. The petitioner also claims that the mores of our nation have changed to the point where physical homosexual intimacy is now part of the fabric of American values, and it's our position this cannot be correct. Even if you infer that various states acting through their legislative process have repealed sodomy laws, there is no protected right to engage in extramarital sexual relations, again, that can trace their roots to history or the traditions of this nation.
Well, their basic argument.
I'm sorry, I didn't get that argument there. I thought you were going to say you were responding to the argument that the morals haven't changed, or that the morals have changed so that homosexuality is now approved. And you respond to that by saying that there's no tradition? I mean, that's a totally different argument from tradition. I mean, the argument is tradition doesn't matter.
Well, tradition does not matter in terms of whether or not it can be a protected liberty interest.
Why do you think that the public perception of homosexual acts has not changed? You think it hasn't?
The public perception of it?
Yes. Do you think there's public approval of it?
Of homosexuals, but not of homosexual activity.
What do you base that on?
I beg your pardon?
What do you base that on?
Well,
I think there ought to be some evidence which you can bring forward.
Sure.
Like perhaps the failure of the federal Congress to add sexual preference to the list of protected statuses against which private individuals are not permitted to discriminate. That addition has been sought several times, and it's been rejected by the federal Congress, hasn't it?
Yes, sir. And in addition, what I was trying to say by the fact that various states have changed their position on sodomy, they've done it through the legislative process. And that's where we believe this belongs, is in the State House of Texas, not this court.
Yeah, but I thought you were responding to the argument that the public perception hasn't changed, that there still is a public disapproval of homosexual acts. And you can't establish that by saying the states have repealed their homosexual laws.
Well, I think it goes back to whether whether people in Texas and people in the other states that have this law on their books actually accept it through their representative government. I think it comes down to the actual people who determine the consensus and mores of the state are the elected legislators.
Might there be a difference between the people's willingness to prosecute something criminally and the people's embracing of that as a fundamental right?
Well, certainly. And just because someone has decriminalized sodomy doesn't mean that they've embraced that practice as something that ought to be taught in the schools, as was mentioned before.
The argument of Bowers, to overrule Bowers, is not directly related to sodomy. It's related, but not directly. It's that people in their own bedrooms, which have their right to do basically what they want. It's not hurting other people. And the other side says Bowers understated the importance of that. It got the history wrong. It didn't understand the relationship of the sodomy to families. And in addition, Bowers has proved to be harmful to thousands and thousands and thousands of people, if not because they're going to be prosecuted, because they fear they might be, which makes it a possible instrument of repression in the hands of the prosecutors. Now, that's the kind of argument that they're making. Harmful in consequence, wrong in theory, understating the constitutional value. Now, how do you respond to that?
Okay. First of all, let me correct something. It's very minor at this point, but the allegation was made in petitioner's argument that people convicted of homosexual conduct are banned from jobs and housing and all that kind of thing. In Texas, homosexual conduct is a Class C misdemeanor. That is, it is the lowest misdemeanor or the lowest prohibition that Texas has.
That I didn't bring in my question.
Yes, sir.
My question was getting those sort of 3 or 4 basic points. I'd like to hear your straight answer to those points, because on their face, I'm not a criticism. I mean directly responding to the question.
Well, it's our position that the line should be drawn at the marital bedroom, through which that law enforcement or anyone else cannot pass unless something illegal happens inside that bedroom.
Well, if this is drawing the line at the bedroom door, this case is inside the bedroom, not outside. That's the statute makes criminal, to my understanding of it, what takes place within the bedroom through consent. Am I right about that?
You're right about that.
And why isn't that something that the state has no business getting involved in?
First of all, let me say that...
Because it doesn't hurt anybody.
First of all, let me say that consent may be alleged in this case, but consent's not proven in the record of this case. There is nothing in the record that shows that people are capable of giving consent or that consent was in fact given. But even given that, I think that this Court, having determined that there are certain kinds of conduct that it will accept and certain kinds of conduct it will not accept, may draw the line at the bedroom door of the heterosexual married couple because of the interest that this Court has, that this nation has, and certainly that the state of Texas has for the preservation of marriage, families, and the procreation of children.
Does Texas permit same-sex adoptions, 2 women or 2 men to adopt a child or to be foster parents?
I don't know the answer to that, Justice.
Well, in portraying what Texas sees as a family and distinguishing both married and unmarried heterosexual people from homosexual people, those things wouldn't go together if the state at the same time said same-sex couples are qualified to raise a family and can adopt children, can be foster parents. You don't know what the Texas law is on that?
I do not know what the Texas law says in that regard.
I think it would be relevant to your argument that Texas is making this distinction between kinds of people who have family relationships and can be proper guardians of children and those who can't.
Well, again, Your Honor, we're not saying that they can't be proper guardians, and we can't say that they can't raise children. That's not the issue. The issue.
You're fairly certain that they can't procreate children, aren't you?
We are sure that they can't do that. But we're also not penalizing their status. We're penalizing only the particular activity that those unmarried couples may have with respect to whether they have sexual intimacies.
Does Texas prohibit this sexual intercourse between unmarried heterosexuals?
Well, it used to. It does not do that now unless the sexual intimacy is in public or where someone might
no,
be.
No, but say in a private situation like this, it would not be prohibited.
It does not criminalize it. It does not condone it.
What about adultery?
I beg your pardon?
What about adultery?
Again, adultery is not penalized in Texas, but it is certainly not condoned in Texas.
So you said procreation, marriage, and children. Those were your 3 justifications. Now, from what you've recently said, I don't see what it has to do with marriage, since, in fact, marriage has nothing to do with the conduct that either this or other statutes do or don't forbid. I don't see what it has to do with children, since, in fact, the gay people can certainly adopt children, and they do. And I don't see what it has to do with procreation, because that's the same as the children. All right. So what is the justification for this statute other than, it's not what they say on the other side, is this is simply, I do not like thee, Dr. Fell, the reason why I cannot tell.
No, sir.
What is it aside from that?
I think what I'm saying is, and I had not gotten into the equal protection aspect of the argument yet, but under the equal protection argument,
Texas has the right to set moral standards.